Good afternoon, everybody. We're about to start our third and final panel of the day before we get to the much anticipated throwdown between IJ senior attorneys Diana Simpson and Sam Gedge. The name of this panel is Originalism and Change. And so what we're going to look at is how the different original state constitutions were adopted, because they were not all adopted the same way, whether that impacts the amount of weight we should put on provisions in those state constitutions from an originalist perspective, and also how those state constitutions have been formally amended over the years. The way this is going to work is our two paper writers, they're on the other table, will each go first consecutively. After that, our commentator, Professor Claeys, will give commentary. Hopefully that'll lead to some back and forth discussion, and then we'll finish with audience Q&A. So while this is going on, if you have any questions, just put them in the back of your mind, and please go up to the microphone towards the end of the panel. I'm going to stagger the introductions. I'm going to introduce each person when it's their part of the presentation. And first up is Peter Allevato. Peter is an associate at Consovoy McCarthy here in Arlington, and he clerked for Judge Timothy Timkovich, at the 10th Circuit, and for Chief Judge Dan Domenico at the District of Colorado. Peter practices constitutional, administrative, and appellate litigation, and he regularly litigates state constitutional issues. Peter's paper is named Originalism and the Weight of the First Declarations, a Case Study in Free Press Provisions. Take it away, Peter.
Thank you very much. It's really a pleasure to be here talking with everyone and talking about such a cool subject. So the topic being originalism and change, I'm basically the originalism side of that. My disclaimer for my talk is, of course, that I am not a scholar. I'm not a professor, and I'm not an academic. I haven't written a lot on originalism. I haven't written a lot on anything. But I am rather a practitioner of originalism. And so my approach, I guess, is a little bit more pragmatic in terms of how do we actually use these documents as lawyers going into court? How can we make use of them? How can we interpret them? How can we interpret the federal Constitution in light of them? I do practice in a lot of areas that touch on state constitutions. A lot of our cases at Consovoy McCarthy rely on provisions from state constitutions and depend on how they operate, and some of those provisions go all the way back to the original declarations and the original constitutions. So it's always a fascinating place to start. Which reminds me, I should also say the disclaimer that I'm here expressing my own personal opinions, not necessarily the opinions of my firm or any client. But with that out of the way, for just the 30-second overview on originalism for anyone who's not intimately familiar with it, it's an interpretive methodology when approaching a constitution to first assume that the interpretive meaning of any provision in the Constitution was fixed at the time that it was adopted and ratified, and that the meaning should be synonymous with the meaning that was generally accepted by the public, or as the public would have interpreted it at the time that it was adopted. So it was fixed, and it was based on the public meaning of that text rather than the intention of those who drafted it or any sort of idiosyncratic view on how the document was read. And that sets up a very unique relationship between the U.S. federal Constitution and all of the different state constitutions that were already in place when it was ratified and when the Bill of Rights was drafted and ratified. We've heard a lot today about the importance of these documents, their political significance, their significance going forward for our country, and just, but also how unique they all were. There are many different ways that these documents were drafted and ratified. They contained many different provisions. They set up governments with different structures, some of which would seem very unfamiliar to the governments that we see today, either in the states or at the federal level. And because of that, it can be very difficult to look to the state constitutions as contemporary evidence for what the federal Constitution meant when it was adopted. And yet, many scholars, practitioners, judges, when looking to the federal Constitution and the Federal Bill of Rights, seem to sort of instinctively jump to the original declarations and the original state constitutions as a place to look for evidence of meaning. And I think that that's a mistake, in particular because there is a tendency to treat the state constitutions when engaged in this endeavor monolithically, that a scholar might say, well, 7 out of 13 original constitutions had this provision. They must have all agreed on what it meant, and that carries forward to the federal constitution. Or, well, we can find this provision in a few state constitutions, so everyone must have known what it meant. And when you start to look, but the deeper that you look into the drafting histories and the ratifications of all the different state constitutions, the more you begin to realize that it's going to be a far more complicated question each time that you look, basically as you get to a more granular level. Once you start looking at an individual state constitution, how was it drafted, who wrote it, how long did it persist before it was rewritten? That's something that I'm sure we'll get to when we talk about change. And then as you get to individual provisions, even if multiple states had, for example, a protection on the right to bear arms, many of them were written using different language, or they were written after consultation for different sources. And because of that, you just have to be a little bit more careful when you're relying on state constitutions to interpret the federal constitution. And you have to find sort of through lines that start with where were these documents coming from, who was writing them, what sources were they considering, to what language did they adopt, was it ever interpreted, were there any statements or debates heard about how it was around the time when it was adopted, and then were these documents relied on when writing the federal Constitution. And unfortunately, in part because of just the fragmented documentary record that exists of the time, it's really hard to find those through lines. So for most of the rest of my time, I would kind of just like to talk a little bit about some of the highlights and lowlights from the state constitutions that ought to, that kind of inform why I think this is such a difficult thing to do. My paper in particular, I chose to study free press provisions because it was the freedom of the press was obviously something that was very important in all of the different colonies, and it was a provision that appeared in the majority of the state declarations of rights, but it's also not one that has been as aggressively litigated as, say, the right to bear arms, the right to free speech, or freedom of religion. And so I thought that it was kind of a middle road place to start. And what I found was, a pretty wide discrepancy in the texts that the different declarations used. For example, 3 different state declarations used the language that the liberty of the press shall be inviolably preserved. Okay. But in Virginia, the language was that the freedom of the press is one of the great bulwarks of liberty and can never be restrained but by despotic governments. North Carolina adopted that same text basically verbatim. But then Pennsylvania had a provision: the people have a right to freedom of speech and of writing and publishing their sentiments. Therefore, the freedom of the press ought not to be restrained. So there we see a combination of speech and press, something that we didn't see in any of the other declarations until the Federal Bill of Rights. In Georgia, interestingly enough, we had a combination of the freedom of the press and trial by jury to remain inviolate forever. No real explanation or understanding in the historical record of why those were combined together. And yet, this is kind of the disparity that you see when you start comparing across different constitutions, across different declarations, and it makes it really hard to ascribe one single meaning across all of the different states, all the different colonies, all the different constitutions that we can then carry forward to the Federal Bill of Rights. Particularly when you consider the fact that many of these state constitutions were drafted either in haste or in secrecy. And we don't actually know that much in many cases about who authored them. And even in the ones where we do know who authored them, sometimes even that can't really tell us much, except perhaps that maybe we shouldn't necessarily assume that this one author was writing a document that would be generally accepted by all. For example, in Delaware, allegedly, the original Constitution was written by Thomas McKean. And sort of in an apocryphal story, it was said that he wrote the entire Declaration, quote, during an all-night session at a tavern with nothing more than ink and a quill pen, unquote. There's some message in there for the students in the room about like pulling all-nighters and writing papers, but I don't know exactly what it is. So I think that when you start to dig deeper and deeper into these historical records, and as you start to see more and more of these discrepancies, one thing jumps out that becomes a real problem for originalists, and that is the duration of so many of these provisions. As we're going to hear, state constitutions change a lot more frequently. They're amended a lot more frequently than the federal constitution, and the original declarations were no exception. Many of them had already been replaced in one form or another by the time the Bill of Rights was ratified. Some of them, didn't last 10 years, some of them didn't last 20 years, and it can be it's a real risk to allow kind of the dead hand of history to control our interpretation of the federal constitution today, when the interpretive meaning, or rather when the provisions and sources that we're looking at were themselves rejected within 10 or 20 years. And I think that this is something that we've seen the Supreme Court kind of grapple with in a few different cases, in particular in the Second Amendment context. In the Bruin case that I think was mentioned in one of the earlier panels, the court said that not all history is created equal when it comes to interpretive intent, and I think that when it comes to the original state constitution, that is particularly true. And originalists have to be very careful looking at them monolithically. Instead, you have to do the work. You have to find through lines for each individual constitution and each individual provision.
Thank you. Thank you very much. Next up is Professor John Dinan. He is a professor of politics at Wake Forest University. He has authored several books that are relevant here today, including State Constitutional Politics, Governing by Amendment in the American States, and the American State Constitutional Tradition. He has also served as editor of Publius, the Journal of Federalism, and Professor Dinan's paper is named State Constitutional Amendment Processes and Development of State Declarations of Rights. Take it away, Professor Dinan.
Thank you very much. So my focus today is on how bills of rights in general are updated. So due to the rigidity of the federal amendment process, updates to the federal Bill of Rights take place through the judicial process, through Supreme Court decisions interpreting existing provisions. If we turn to state declarations of rights, we would find state Supreme Courts playing a role in updating and developing state bills of rights. But we would also see amendments playing a very regular role in this process. One way of kind of appreciating this difference between the state and federal approaches is to think about how differently we would tell the stories of the development of state bills of rights from federal bills of rights. Amendments would loom large in any account of the development of state bills of rights. Yes, state Supreme Courts would come into the picture for particular notable decisions, but amendments would figure at least as prominently as Supreme Court decisions. Very different story where treatises on the development of the U.S. Bill of Rights are going to focus, with the exception of the 14th Amendment, they're going to be told entirely about U.S. Supreme Court decisions. So I have two purposes today. One is to make a case for the extensive reliance on amendments to update state bills of rights, and then two, to assess the consequences, focusing really on leading benefits. So let me start by highlighting the extensive reliance on amendments for altering and adding to state bills of rights. Just consider Virginia's 1776 Declaration of Rights. 16 original provisions. It's true, half have been unaltered, but the other half have been changed and new provisions have been adopted. Let me zoom out from Virginia and just look more broadly, making a case for some of the more notable changes to state bills of rights across the country through amendments. And I should say these amendments come mostly through legislative-generated amendments, in many cases through convention-generated amendments, and where possible through voter-initiated amendments or commission-generated amendments. So what are some of these rights that have been expanded via amendments? Well, religious establishment clauses were amended very regularly in the 19th century for the purpose of providing more specific and detailed restrictions on public funding of religious schools. Religious free exercise provisions, especially in recent decades, have also been amended to require more demanding tests when assessing practices challenged as violating religious liberty. Right to keep and bear arms provisions have been frequently amended through the years, invariably for the purpose of strengthening the right, making clear it's an individual and not a collective right, and requiring demanding restrictions on any practices challenged as violating the right. Other amendments that have been expanded existing rights, takings clauses, of course, have been adopted regularly. In the 19th century, it was to make clear that takings clauses applied not just to taking of, but also damaging of property. And of course, post-Kelo, there were a dozen amendments that were adopted to make clear about what qualifies as public use with an idea to preventing economic development's takings. And then amendments have also amended search and seizure provisions, invariably for the purpose of updating the items that are subject to these. Most recently, for instance, saying that search and seizure provisions apply to electronic data and communication. These are the kinds of amendments that you see passing to update existing rights. Other amendments add new provisions, protect rights not yet in the document. So a lot of anti-discrimination amendments. Let's ban gender discrimination, sexual orientation discrimination, disability discrimination. All these come place through amendments. Or victims' rights provisions, added to over 2/3 of the state constitutions. Or, beginning in the 1970s, personal autonomy amendments. A handful of states put in a right to privacy in their constitutions. And then, since Dobbs, 10 states have enacted amendments explicitly protecting abortion rights. Well, turning to the motivations for these amendments, I'll use those abortion amendments as the two main motivations. Some of these amendments are intended to entrench understandings that courts are already inclined to embrace and sometimes already have embraced. Some of those, actually a majority of the 10 abortion rights amendments, were passed when state courts were already disposed to do so. It was just entrenching those rights further. But another motivation is sometimes state courts have not yet embraced an expansive understanding, and the purpose of the amendment is to achieve this goal by an alternative means. The courts won't do it, we will require this to be done. At least 3 of the 10 abortion rights amendments have been enacted for that purpose. So I focus so far on the vast majority of amendments that are passed to expand rights and empower courts in that way. But I should be clear, other amendments are passed to constrain courts, to prevent courts from expanding rights in expansive ways. Just to give a few examples here, some amendments have responded to state court decisions on fair trial guarantees. Courts have been expansive. Amendments come in and saying actually less expansive is what we'd expect. One other example here, a fair number of amendments adopted to clarify the meaning of cruel and unusual punishment to make clear with an eye towards preserving the death penalty in the face of state Supreme Court decisions that would overturn the practice. So my point is there's extensive reliance on amendments to update bills of rights. But let me turn to the second part of my discussion. What are the consequences of doing so? I want to set out 3 leading benefits of proceeding to update bills of rights in this way. First, I would argue the availability of amendment processes, in addition to judicial processes, offers a wider range of avenues for groups and individuals to pursue changes in understanding of rights, and I'd argue this is consistent with a pluralist form of government that disperses influence and means of influence. When amendment processes are inaccessible, groups devote nearly all of their energy to influencing the courts. And especially when you have an inaccessible amendment process and a life tenure court, that can place extraordinarily unhealthy weight on filling judicial vacancies. Anytime you get a judicial vacancy, all eyes are focused because everybody understands that's your main avenue for shaping rights in an inaccessible amendment process. But when amendment processes are accessible, groups have additional opportunities. You try to persuade legislators, propose this amendment, or in places where it's available, persuade voters to place amendments on the ballot through the initiative process, and then persuade voters to vote up or down for those amendments when they are on the ballot. On a number of occasions, we've seen groups that are seeking to expand rights. They're not successful working through courts, so they pursue an alternative path. And they say, we're going to get our pathway through amendment processes. You've seen this in regard to economic development takings areas. You've also seen this in regard to right to keep and bear arms. So that's a first benefit, I would argue, of updating bills of rights through the amendment process. A second benefit, relying on amendments to update understanding of rights, can be also seen as appropriate for a Republican form of government, in that it gives the public an opportunity to shape the meaning and scope of rights. Again, when amendment processes are inaccessible, the public has limited opportunities to shape understandings of rights. Let's think of at the federal level. What are your opportunities? Well, you can vote for a president who will nominate justices. You can vote for senators who will then decide to confirm or deny justices. That's really the extent of your meaningful opportunities as a member of the public to shape rights. By contrast, when state amendment processes are accessible and viable, voters have more direct and more significant opportunities. Every state but Delaware requires amendments to be ratified by the public. So that means in every single state, amendment processes require direct public involvement in any changes to bills of rights. Moreover, when state courts hand down rulings embracing an understanding of rights that fails to command popular support, amendments have been a vehicle for ensuring that the public's understanding is ultimately the one that prevails over the judge's understanding. I would argue these benefits of regularly resorting to amendments to update bills of rights are particularly evident in these cases where judges' commitment to a particular understanding proves to be at odds with the public's understanding. Certainly, there's no expectation that the level of protection for rights should mirror exactly public opinion in that sense. A deliberative government doesn't make you a mirror. It can require some gap there. They should always be able to obtain the deliberative sense of the community rather than the immediate sense of the community. But when courts retain nearly exclusive responsibility for rights and amendments are not an option, runs the risk of producing, I would argue, a significant and sometimes unhealthy gap between the public's understanding of rights and the understanding that prevails. Let me turn to a third and final benefit of updating bills of rights through amendments, and that is to boost the legitimacy and endurance of these rights in a way that can be seen as consistent with a constitutional form of government. When amendment processes are inaccessible, it falls to judges. And how do they expand rights? Well, you reinterpret, you reapply existing rights, you discover new rights embedded in generally phrased provisions. I mean, that's how things work when the judges have the day. But when updates are made through formal changes in the constitutional text, it tends to better entrench these understandings against the possibility of changes in the disposition or composition of a future court. I would also argue that changes achieved in this way are also rendered more recent amendments explicitly, for that reason, more likely to endure. Consider a number of the recent amendments explicitly protecting abortion rights. I've already mentioned several were enacted when state courts were not inclined to protect abortion rights. But others I mentioned were amended when amendments were passed when state courts were already on board. We were already protecting abortion rights. So what was the advantage of doing this through passing amendments? Supporters of the amendments believed they weren't content to allow this right to rest on generally phrased guarantees. They wanted to put that explicitly in the Constitution to entrench it. I'll close. We're so familiar with the federal approach to updating rights. It's the job of the courts. They'll do it. The state approach is very unfamiliar to us. I would argue the state approach has a lot of benefits and virtues that we become familiar with.
Thank you very much, Professor Dinan. And now it's time for some commentary. Our commentator is none other than Professor Eric Claeys, law professor right here at the Antonin Scalia Law School. Professor Claeys clerked for Judge Melvin Brunetti at the Ninth Circuit and for Chief Justice William Rehnquist at the U.S. Supreme Court. He also practiced at Kirkland & Ellis's D.C. office. Professor Claeys studies the influence of natural law and rights on American law. And last year, he published his first book, Natural Property Rights, with Cambridge University Press. So, Professor, what's your commentary?
Thanks for the introduction. Thanks for that question, getting me right into the commentary. Before I do that, I want to apologize. My hay fever's bad this year. But then I also want to thank the Liberty and Law Center and Institute for Justice for putting on this conference. And I want to thank John and Peter for very interesting, rich papers, and they give a lot of food for thought. I probably have faster reactions to Peter's paper because Peter and I are both lawyers, and I have a lot of opinions about originalists. And John's paper is interesting. John and I may suffer from a divide. There's a statement that's sometimes attributed to Churchill, sometimes to George Bernard Shaw, and sometimes to Oscar Wilde, that the English and the American nations are too separated by a common language. And political scientists and law professors, when they talk about court decisions, can be the same. though it's kind of complicated. So I'm going to start with John's paper and offer a few different questions or challenges, and then go to Peter's paper. And then, so to preview the two challenges or areas where there might be disagreement, I'll give two sources here. So one is, I'm going to discuss a little bit HLA's Hart's The Concept of Law, Chapter 7 on American Realists. And then the other, that's going to be I'm going to have an analytical concern that's associated with Hart. And then I'm going to talk a bit about Federalist 49 and Madison's account of republicanism on the normative. But before I get there, let me kind of diagnose the parts of John's paper. On the first page, he says that the paper is documenting what happens in states. So that part of the paper is empirical, descriptive. And then he also says when he's documenting by categories. There's different kinds of amendments, and you heard that in his talk. That part's analytical. And so part one of the paper is both empirical and analytical. And then part two, he talks about on page one assessing, he's talking about benefits in the back half of his talk. That's the normative part of the paper. On the first part, the empirical part, I found that very interesting, and I learned a lot. And I have two questions, and I don't mean that you must do something. It just meant for you to think about what to do with the next draft. So if you keep the focus on the categorizing different rights, like amendments on rights by different topics, is this the first paper to have done that kind of empirical work or not? It read to me like it was the first. If it's not, please make clear what the others are and what value you're adding. But I don't know the literature, so it's a naive outsider's question. The one other suggestion for the empirical part of the paper is instead of organizing around rights and all the different rights topics, the paper could say a lot more about the specific processes by which states, when they ratify amendments, how the ratification process happens if it's not by a popular referendum, full stop. The paper you wrote is interesting. That's maybe a different paper, maybe a separate research. So now to the analytical part of part one. And here is where the apocryphal quote from Churchill and Wilde and Shaw comes from. And it's actually not a disagreement between all law professors and all political scientists. It's between most law professors and all political scientists on one side, or most political scientists on one side, and then more formalist law professors and maybe institutionalist political scientists who study courts. And so in the way that John set up his talk and the way he structures the paper, it suggests that there's not a lot of difference between when a court construes and interprets a constitutional rights declaration and makes it binding in case law, and when the legislature and or the people change it. And that for a law professor who's teaching jurisprudence right now, that reminds me very much of H.L.A. Hart dividing with the American legal realists. The legal realists are famous for saying that the law is what the judges say it is in the last cases. But Hart resisted this line of argument, saying that when a judge decides a case, the judicial decision is in the same position as a ruling by an umpire on a strike zone. And if the ruling on the strike zone it can be judged by the rule book that defines the strike zone. And so the analytical parts of me, the more formalist parts of me, want to resist this suggestion that the de facto constitution is amended by judicial decision. And I don't know what you're going. That's going to lead me then to the normative part of the discussion. So I think I'm persuaded, John, by the normative argument you make. But if I were to give the best argument going the other way, it would run with Federalist 49. And so you said in your remarks that you're saying that the ratification amendment process has Republican virtues. Short term, I think that's right. Long term, maybe not. And so there may be a disagreement among Republicans about what the best means are to secure Republican goods. And so when I keep referring to Federalist 49, I'm referring to a passage in 49. In 49, James Madison considers an argument in which there's a proposal in which there could be a constitutional convention every time the legislature and the executive and the courts, 2 out of 3 disagree on some topic, there's a confrontation. Madison argues it's a bad idea, and the key in the money quote, he says, that a process of letting there be a popular convention to settle disputes among the branches would deprive the government of that veneration which time bestows on everything, and without which perhaps the wisest and freest governments would not possess the requisite stability. So the advantage of having courts construe a constitution is if the people think they get it wrong, then you can have the people complain about that, criticize court decisions. And we've seen that for the last 50 years with Roe v. Wade and Dobbs versus, and the Dobbs case. And one thing that then happens is that active concerned political groups become part of big coalitions. And the other thing that happens is the Constitution seems more the touchstone of all the politics instead of something that the people can play with. I mean, there are jokes about the French and how often they flip around their constitutions. You could say that states are very French in that respect. And one of the advantages of making the Constitution hard to amend is that it sets a standard to measure what happens in politics and in courts. So now on to Peter's paper. And so the preview for my suggestions to Peter is read what Judd Campbell, most of all, and then Will Bode and Steve Sachs have said about originalism. And so what do I mean by that? So Peters is suggesting that there needs to be a lot more careful work of the specific clause meanings of rights declarations in states' constitutions. I agree. He says that right now that we don't. There's too much of a focus on, in the beginning of the paper, quote, the bare provisions, close quote, of the text of these rights declarations. I agree. Why is that? Because that's all we have. We don't have lots of evidence about. We don't have anything like Madison's convention notes for a lot of the state constitutional debates. We don't have nearly as rich press reports about what happened when these different rights declarations were ratified. That's all true. But so then the question is, if one is an originalist, what are all the relevant sources of evidence? And what I've recounted, what Peter recounted in his talk in his paper, I think he's covered two legs of the stool, but not the third. So the first leg consists of specific text in the rights declarations, and the second consists of original source evidence like newspaper debates, convention records. But then the third is something that's become a hot topic in originalist scholarship the last 10 years, and that's called the general law or the customary international law. The idea here is that the Constitution wasn't just something that came out of nowhere. It was taken for granted that the principles of social compact theory were binding as a matter of general customary international law. And so when one is an originalist, one of the things one needs to do is to understand the state of the general law before the Constitution was ratified. In the same way, if you're reading a statute that changes the common law, you need to know what the common law was and what changes the statute's making to the common law. And so Judd Campbell done a nice article on this in the University of Illinois Law Review about the methodological implications. I recommend that to you. And then he wrote a piece in the Yale Law Journal about free speech guarantees, and that's close enough to liberty of press guarantees. I think that's a helpful source. And so for example here, one could look not only at the sources that Peter looks at, but one could also look at William Blackstone's commentaries on the laws of England. And so when he talks about the liberty of the press, he takes for granted that the liberty of the press is consistent with state laws that restrain blasphemous, immoral, treasonable, schismatical, seditious, or scandalous libels. And he says the liberty of the press, properly understood, is by no means infringed or violated. Why? Because the liberty of the press is indeed essential to the nature of a free state, but this consists in laying no previous restraints on publications. Translation, so when you see words like inviolate in these state guarantees, you might be led to think there can be no limit whatsoever on the liberty of the press. If, however, one understands that there's a background common law, and the background common law means that there's a right of free speech and a liberty of the press, but these are rights to use the liberty responsibly and not licentiously, and there are common law limits on licentious use of the right, then inviolable isn't the focus of the text of the state guarantee. The word liberty and what's in a morally ordered liberty is that you need to unpackage that much more using a source like Blackstone. So I suggest the next draft of the paper, you consider the implications for a general law approach, and you also consider like the specific sources, the general law sources, like the commentaries of the Law of England, Story, William Rawle, and how, like, what they had to say and how that might enrich one's understanding of the original public meanings of state rights declarations. And that was my time.
Thank you. Professor, I really appreciate your willingness to stay on time. That makes my job so much easier. Now, Peter or Professor Dinan, would either of you like to respond to those comments or even make comments about each other's papers?
Yeah, no, let me. Difference. I've said there's two alternative paths. You either amend the Constitution or the judges are doing the job and have actually aptly characterized what judges are doing in that case. Let me use a paper that was just from the previous panel, the one about Pennsylvania. What should be the standard for judging this right to work question? Should there be a right to work? Notice how all the attention is focused on persuading these judges, hoping these judges will kind of buy this kind of, will accept this, or should the judges change their kind of the test that they're using. All throughout the panel saying this should be, let's resolve this by constitutional amendment. I mean, what are we doing? Our audience is purely some judge and several judges who might change, depend on kind of if their mind changes in that sense. I mean, I'd love for IJ to be the institute of the judicial engagement, for it to be constitutional amendment engagement. I would love for that to be the focus in there, since let's resolve this. Let's make sure the people of Pennsylvania, let's put that before them and say the test, first of all, there is a right to work in here, and this right to work should be judged through an expanded rational review test. My sense is that those are basically interchangeable. We're either having judges decide what test there should be or whether there's a right to work, or we're having the people decide it through a constitutional kind of sense. So I would make the case that we really do have alternative paths. Let me go to the second kind of point about Federalist 49. Let me say this, my mentor at University of Virginia has Fed 49 on his license plate, on his Virginia license plate. We had a lot of discussions about this, James Caesar at the University of Virginia. It's taken, I should say. So for folks in Maryland, you could do this, and in DC, but Virginia, that's not an option because that's already been taken. Here's the way I would kind of say this, is that very point, so we would have these debates, and it's a debate very much to have. Yes, Madison said, you want your Constitution to be venerated. Are you really venerating a Constitution that's changing as often as Professor Cole was showing us in his first remark, that some constitutions are changing in that sense? How is that? How can you, that is, veneration, respect comes from longevity and unchanging nature. But Jefferson's view, and this is of course the view that's won out at the state constitutional level, is no, respect and legitimacy comes from ownership and participation. And someone saying, I actually voted on that, or in 14 of the states, very Jeffersonian, it's presented every 20 years, or in Michigan every 16 years, or in other states every 10 years. The question is put to the people, do you want to call a constitutional convention or revise your Constitution? Jefferson, of course, believed a generation was 19 or 20 years, so it's very Jeffersonian. And that belief is, even if you vote no on that, say, no, I don't want to call a convention, you had that chance, and therefore you claim ownership of that Constitution. So two very different kind of views. I'm very aware of the, and very attuned to, and very key points about the downside of Madison would look at this and say, do you even really have a Constitution here? What is this? Jefferson would come back and say, oh, you very much do. It's just a different view toward that. Let me stop here.
Peter, is there anything you'd like to talk about?
Yeah, I guess I had one thing, maybe a little bit in response to Professor Claeys, and then kind of a question for you, Professor Dinan. So, in response to considering the common law backdrop that Bode and Judd Campbell have talked about, I've read some of their work. I haven't read it exhaustively, so I could be completely wrong. But I feel like the sort of the critique that's in my paper would probably still apply even in a common law backdrop sort of context, because the historical record seems so thin that we don't actually know whether Thomas McKean in his tavern was, thinking about the common law backdrop when he wrote his Constitution. We don't know. We do know. I think that Bode and Judd Campbell are probably right, that we do know that the founders in the, when they were writing the U.S. Constitution and the Bill of Rights have that sort of backdrop in mind, but I'm just not sure it's there for the state constitutions. If they have written about that, I would love to know about it, but I don't know about it. And then Professor Dinan, I was curious in your paper, maybe somewhere where our papers a little bit intersect, is the process of amending state constitutions by convention, right, rather than just by proposed amendment either by the legislature or by the people. A constitutional convention hasn't happened in my lifetime in any state, but there have been ones certainly more recent than our last federal constitutional convention. And I wonder if in your research for this paper you've noticed any sort of different characterization in how constitutions get amended by individual amendment process as opposed to the types of changes that come about in constitutions when they're amended by convention.
No, thanks very much for that question. That gives me a chance also to kind of address something that Eric brought up. Yeah, I do very briefly say, okay, so I'm going to talk about the content of these amendments. Let me spend a paragraph on the process of this. Let me, like all good questions come at these forums, let me take that opportunity to get some more time for myself and talk about it. No, I'll be brief. But yeah, I mean, what are the ways is 90% of the amendments that are passed in any given biennium come through legislative generated amendments. Now, this is very much a current question in Virginia right now in terms of the process for that takes place. Virginia is one of the states that requires the legislature by majority vote in 2 sessions, separated by an intervening election to advance something, and then it gets ratified by the people by majority vote. Some states say, no, it's just 1 legislative session. Some states say 1 legislative session by a supermajority. In terms of ratification, about 42 states say it's just a simple majority vote. That's all it takes. New Hampshire says it's a 2/3 vote. Florida, for the last 20 years, has said it's a 60% vote. Colorado, for the last decade, has said it's a 55% vote. Some other states, it has to be a majority of voters casting votes in the entire election. Therefore, ballot roll-off basically counts as a no vote. So there's a wide range of ways. Nevada for vote, and then 17 states allow voter-initiated amendments. Those states generally are majority vote, or as in Florida, 60%, except Nevada. Nevada says if a voter's initiated amendment, it has to be approved in 2 consecutive elections. So actually Nevada could become the 11th state to pass an abortion rights amendment. They passed it once, but then they come back and do it again in that sense. So there's a wide range of ways that ratification takes place. Conventions have been held between about 235 and 250 times throughout American history. Conventions have been held quite regularly until recently. Rhode Island Constitution of 1986 is the last time that a full-scale constitutional convention has been held. That's the longest time that we've gone without conventions. That's a story in itself. The Pandora's box concern, the belief that people used to actually view these as conventions as a chance for the popular will to merge. Now when people see a convention vote on the question, it's like, oh, it's just those same government officials and special interests operating. They don't see it the way it once was seen as an opportunity for kind of the public voice to emerge. And so, yeah, ever since 1986, these questions keep coming up, as I say, Jeffersonian style in the 14 states, except for Oklahoma, which is the only one that doesn't do its duty and hasn't put it on the ballot since 1970. I was at this conference in Oklahoma. I kind of made that point very broadly, loudly. They still haven't put it on the ballot. In any case, voters say no to that now in that sense. Conventions, a final point I'll make, I've taken too much time with this question. Conventions, the virtue is you can take a bird's eye view of things. You can say, how does this fit together? Rather than when it's piecemeal amendment, where California passes Proposition 13 and puts a tax, says taxes should be limited, and then 10 years later comes back and says, but education spending must increase by this amount. Those don't always cohere. A convention delegates at least could see how those all fit together in a way that would be more healthy.
So in a minute, we're going to turn it open to the audience to ask questions. But since you mentioned IJ, Professor Dinan, I need to say something or ask you something. And I should preface this by pointing out that I can't speak for all of my almost 200 colleagues. But personally speaking, one of my favorite things about constitutions is the fact that they provide limits on the tyranny of the majority. And personally speaking, I think one of the most important times to defend individual rights is when it's unpopular to do so. Now, I take some of your points about the impact on the judiciary and how if they're going to be amended anyway, it's better to do it through a formal process than having judges do that. But setting that aside, you also seem to be going one step further and saying that frequent amendment is in and of itself a good thing. If I think I'm understanding you correctly, and if so, are you worried at all about the pitfalls that might come along with over-amendment?
So here's how I'd phrase it. Frequent amendment is not necessarily a bad thing, is what I would say. So I don't want to advocate for, let's put it this way. Texas, in November 2025, when they passed 17 amendments. There were 17 amendments on the Texas ballot. The voters approved 17 of them. One of those amendments, interestingly enough, was a new right, a right for parents to direct their children's upbringing. They weren't content for judges to be possibly supporting that or not. They said, let's put this in the text and let's do that. 17 is a lot. 17 is a lot, and I wouldn't want to kind of be coming here and saying that, wow, that's a healthy way to kind of go about things in that way. On the other hand, I think it's unhealthy that the U.S. Supreme Court, that the U.S. Constitution has only been amended 27 times, and 10 of those were the Bill of Rights, and one of those was prohibition, then removed in that sense. That puts a lot of pressure on the Supreme Court. Way more pressure than the Supreme Court than is healthy to do so. Where is that exact kind of too much, not enough? It's somewhere between Texas and the U.S. Constitution.
I think that's fair. Does anyone in the audience have any questions?
This is so unusual for a post-lunch session.
I'll be quick.
Go ahead.
John, can I put you on the spot? Because you make some normative claims about desirability of amendment. What is the best and worst method of amendment? Can I push you on the sort of normative claim you might make about mode of amendment? And Peter, do we need to draw a distinction between original public meaning for the federal text, where we have a lot of papers like the Federalist Papers, the ratifying convention papers, and the convention met in secret, and the records are not available till 1819 at earliest, and state conventions where the records are public from the beginning and available. Footnote, I don't really accept the characterization that they are quite as thin as some people would like to suggest, but the fact that conventions were public, reported on at the time, and the records were immediately available, doesn't that make a sort of methodological distinction between what you might look for to fix meaning?
I think that one of the more unhealthy amendments processes is one in place in 10 states, a simple majority of one session of a legislature followed by a simple majority of public ratification. It becomes difficult to see that much of a distinction between statutory change and constitutional change. In fact, there's been some times where a party controls the legislature and they're blocked by a gubernatorial veto, and so they actually can't get policy through statutory. It's easier for them to get the policy accomplished through constitutional change. I find that unhealthy. One of the things that I find particularly healthy is something that goes back to what Pennsylvania and Vermont did with a council of censors, where every 7 years there would be a body that would come into being that would just take stock and would say, how are we doing in the last 7 years? Are we adhering? Are we recurring to first principles in the ways? And they would, as necessary, call a constitutional convention. Pennsylvania, its provision was repealed by the 1790 convention. The Vermont provision lasted for a century, until 1870, and every 7 years the Council of Censors. We have a bit of an embodiment of that in Florida,
New Hampshire
where every
still
20
has it.
years there is a constitutional commission
I attended
that comes
that, and it
into
was a
being.
mess.
And that's it. Now, it turns out the way they do this is they can get around single subject rules, and so they can end up just throwing 3 things out there that have completely no bearing. So in the practice, I don't like it. In the spirit, I like the idea of periodically reviewing to take stock of.
I'll just tack one thing onto that, which I think the worst method of amending the Constitution that was created was South Carolina's original Constitution, which could be amended by statute by the South Carolina legislature by its normal statutory powers. So what kind of a Constitution is that? I don't know. But to your question about whether or not the immediate public availability of notes kind of helps us understand the state constitutions, I think that it does help, But what it does not help with is the sort of the reverse understanding, which is we know that the public was able to see what happened in these constitutional conventions, but then they were not given a say, for the most part, in whether or not those constitutions were actually adopted. In Massachusetts and in New Hampshire, they were, but in the majority of the, I think the majority of the original constitutions were created by legislature and then ratified by those same legislatures before being put to the public for any kind of a vote. So perhaps knowledge of what was in them you can credit to the public, but not necessarily approval of what was in them by the public.
Sure.
Thank you all so much for being on the panel today. My question is specifically for Mr. Allevato. Is that how you say? Okay. So I appreciate it.
Two in a row getting it right is so rare.
Awesome. I was most worried about that than I was like getting my question right. Anyways, I appreciated how you kind of tied it together at the end, where you're talking about that we should be mainly focusing on looking at state constitutions and finding the through lines between them to then apply that to understand, original public meaning for the federal constitution. And I'd like to pull on a thread of something that has been mentioned actually on the last panel, and then you kind of talked a little bit about it, that a lot of these constitutions were kind of wartime documents that were written in haste, that were not written very carefully sometimes. So I want to know if you think that there is a sort of rationale or an argument for granting more weight to constitutions that had a little bit more time behind them, that may have, I know there was a couple that were not actually issued in 1776 that were written in 1777. So ones that maybe had more robust debate and weren't written just in a tavern with a gallon of ale or whatever in a single night.
Yes, I think that if you read, especially in the concluding pages of my paper, kind of my takeaway is that not that you can't trust the state constitutions generally for original public meaning, but that it's a varied result when you actually dig into the historical record. That some of them you can trust to have a more reliable relationship to the public meaning than others. And I think that the ones that had a much more deliberative process, New Hampshire's was better, Massachusetts was much better. You can trust those to have to be more likely to represent the original public meaning than one of the ones that was drafted very quickly or drafted in secrecy, for sure.
And whether or not it was liquidated in court as well, like in Massachusetts.
Right. Almost very few of these. We heard earlier. Apparently, these declarations weren't even enforceable in court, and as a result, they were basically never litigated, and so we don't have any sort of interpretations of them from judges.
Except for the one in Massachusetts with the newspaper tax.
Right.
Professor, go ahead.
It was fascinating. Really enjoyed both papers and the comment, although I've got a beef with the general law, so I don't know if I would quite sign up for Professor Claeys' take on it. Can I call you Peter? Is that okay? I loved the honesty of your paper. I have a student right now who, tasked with doing a deep historical dive, has basically come to the conclusion that we don't know. So this is a realm for constitutional construction. And I find this type of honesty, which I think history should be humbling at all times because there's so many gaps in it, really refreshing. And so, but more than that, I wanted to push a little bit back a little bit about your comment about, a lot of these didn't last very long. They were 10 to 20 years. And why that would have any bearing on original public meaning. I think it might have bearing on tradition, but that's different, right? Original public meaning is a snapshot. So how would that not be okay to know, okay, this is a snapshot of this time of what everybody's doing? Okay, so that's one question. I don't know if I'm allowed to do this, but Professor Dinan, I also have a question for you. So would you support a constitutional amendment to the federal constitution to make it easier to amend? That's binary. Hopefully that's a permissible question.
Well, First, I sympathize with your student. I started writing this paper when I was a student in law school as well. It was born of a lot of the same frustration, which was I was in a state constitutional law class, and I was like, there's just not enough here. So I understand that frustration. But then the snapshot question is a really interesting one because yes, original public meaning is supposed to be fixed at the time when the text is ratified. But when you look at the original state constitutions and the gap between when those are ratified and when the federal constitution is ratified, and then the further gap between when the Bill of Rights is ratified, if the state constitutions are being amended and being changed in between the time when they're first passed and when the Bill of Rights passes, I really don't know what meaning we can ascribe to the first one if it's replaced by the time the Bill of Rights even comes about. But even if it wasn't amended before the Bill of Rights is put into place, maybe it's amended a few years after and replaced a few years after, you start to get into very thorny issues of did the public, did the snapshot that we take include some laws that the public didn't actually accept but hadn't gotten around to replacing yet? That's a really hard question, and I think you start getting to a very watered down analysis as you keep going further and further into, well, did the public really accept this? Did the public really accept this? Did the public really accept this? It's almost, one of the reasons, again, why I wrote this paper is because it's almost an unusable argument when it comes to lawyering in court, even though I'm sure it's something important for scholars to work out. But I do think that the quick replacement, the short fuse that a lot of these constitutions had counts against them in terms of weight. It might not disqualify them entirely, but it definitely weakens the argument, weakens the support.
Go ahead, Professor.
So on the federal process, I'll note this. So 33, the real bottleneck at federal constitutional change has been at the proposal stage, not at the ratification stage. So 33 amendments have made it through the proposal stage, and that is they've gotten 2/3 of both houses of Congress to approve. There's, of course, the alternative mechanism for 2/3 of the legislatures to petition Congress to call a convention. That's never been successful yet. But of the 2/3, Congress has gotten 2/3 only 33 times. Of course, the ratification stage is 3/4 of state legislatures, or in the Prohibition Repeal Amendment, 3/4 of state conventions in that sense. Only 6 have failed at that stage. So 33 have been proposed, 27 approved. I say that because Texas has the exact same 2/3 requirement of their legislature to put measures on the ballot. And so it's actually not so much mechanics, I would say, as the approach to Constitution. It is so much, when people said after Citizens United, members of Congress said, well, let's amend that. And some people said, well, I disagree substantively. But other people said, no, don't touch our Constitution. Don't deal with that. It's that attitude that I would see as the kind of the more problematic one that I would like to overcome. No, if it needs to be changed, let's change it and not believe it needs to be set aside in some museum room someplace.
Depending on how long this may or may not be the final question, but let's find out. Sir, go ahead.
No pressure.
Mr. Allevato, I just have a question for clarity, basically, that's probably stems from my own naivety, but maybe you can help me out. I'd like to ask, how do we adopt an ordinary public meaning originalism as opposed to a ratifier's intent originalism for the interpretation of same or similar language across different state constitutions that doesn't result in the kind of monolithic interpretation that you avoid? What I mean is I would not expect the ordinary public meaning of words in 1776 to vary between the citizens of Delaware, Pennsylvania, and other states enough to really create the kind of differentiation. So wouldn't we need to look to the intentions of the drafters of these in order to see?
Yeah, that's a great question. I think sort of two responses, neither of which might fully answer your question, but I think both of which will hopefully contribute to an answer. The first is I would push back on the idea that we can't reasonably expect there to be differences in the meaning of terms between the different colonies at the time of ratification. There absolutely were, right? You can even think about things like religion. Right? What was an establishment of religion, or what did constitute free exercise of religion permissibly under a right to religion did differ between the different colonies, just based on the religious backgrounds and the religious makeup of those colonies. Whether or not something or someone could be considered property was definitely something that differed colony to colony, state to state. So that's the first point. I do think that basically pushes back on the premise a little bit. But then as to the second point, I do think Remind me your question one more time. I'm going to make sure I get it right.
Oh, I mean, I guess the second question is look to the.
Oh, yes, it's why wouldn't it be monolithic? Right. The intention of the framers or the intention of the founders when they adopt a specific provision matters more in the ratification debates in the states than it does in the debates when the Constitution is being written. So you might see in ratification debates different people arguing and saying, well, this would lead to a adoption of a right that protects property like Philadelphia believes in property. But here in Virginia, we believe something very different about property. Or you might have like the takings clause. They had a takings clause in the Massachusetts Constitution, but I don't think they had a takings clause in like the Georgia Constitution, right? So when that comes up for the federal Constitution, they were probably wondering, is this going to create just the same takings clause that they had in Massachusetts, or is it going to be something that's more consistent with all of our understandings? In that sense, you're not taking the intention of the founders or the intention of the framers as gospel, but rather you're taking them all as data points and trying to, again, draw the through line that's most consistent with all the different data points.
Sorry to say that's all the time we have, but please join me in thanking our panelists and commentator.